Hello, and welcome to this criminal law taster session. My name's Josey Kemeys, and I'm one of the lecturers in the School of Law at the University of Worcester. This session is going to take a closer look at fatal offences, the offences of murder and manslaughter. By the end of this session, it's hoped that you'll be able to understand a little bit more about the criminal law in this area. And not only that, you'll also have a go at applying that law to a set of facts to assess the potential criminal liability of a defendant. As you can imagine, the offences in this area do require us to think about some fairly challenging ideas. Alongside reading the facts and assessing the information, we'll be looking at some more complicated points of law to help us construct a legal argument and assess the position of the parties involved. Just to say a little bit about how this session will work, because you're doing it virtually, you need to also download an accompanying worksheet which has the question that we're going to look at together on it. It's important that you have that to hand because I'll be moving through the slides at a different pace. I'll begin by giving you a short introductory overview of the law here, and then I'm going to ask you to think about a few particular questions. There's time built into this to allow you to do those tasks. And at each point, you can just pause the video and then pick it up again when you're ready to. Okay, so let's make a start. We're beginning with this overview here. You might recognise these offences either from previous study of law or just from your general knowledge. A few things to say though. Firstly, you'll see that there are two main types of offence listed here: murder and manslaughter. But within the category of manslaughter, there are a further two different types: voluntary and involuntary. Down the left-hand side of this table, you'll also see some other important terms. A couple of these are in Latin and might seem a little bit unfamiliar if you've not studied law before. The first, actus reus, can be understood in terms of an act, and as we're talking about criminal law, a guilty act. The mens rea is a term which refers to the defendant's state of mind and might similarly be talked about as a guilty mind. There are lots of different kinds of acts and even omissions which might feature in different kinds of criminal offences, and there are different kinds of mens rea too. This can range from specific intention to simply having some knowledge or belief about the circumstances. To establish criminal liability, you must be able to establish both the actus reus and mens rea elements of the particular offence. In addition to this, we must also consider whether there is any defence available to the defendant. If none apply, it's possible they may be found guilty. So if you take a look at this table, what observations might you make about the actus reus and mens rea elements of these three offences? So you might have noted that all three offences have the same actus reus: unlawfully causing the death of a human being. You might have noted that there are partial defences only listed under voluntary manslaughter, something called loss of control or diminished responsibility. And you may have seen that involuntary manslaughter does not have the same mens rea as the other two offences. The intention to kill or cause grievous bodily harm is missing for that third category. And it's this last category of offence that we're going to take a closer look at in this session. So having just got to grips with those three types of offences on the previous slide, here's another table to contend with. Under the heading involuntary manslaughter, there are actually another range of possible forms this might take. So you can see here unlawful act manslaughter, gross negligence manslaughter, and even something called reckless manslaughter and corporate manslaughter. So not only are we thinking about those broader actus reus and mens rea elements of murder and manslaughter, but we can see here that these particular forms of involuntary manslaughter have their own elements, and each of these must be established before a conviction can be considered. So just to say a little bit about these different forms of involuntary manslaughter. Unlawful act manslaughter is a form of unintentional killing, because we're missing that mens rea element, and it relates to circumstances generally where a defendant is engaged in some other kind of criminal activity, and it's from that criminal activity that death results. That's unlawful act manslaughter. Gross negligence manslaughter is a bit different. Here again we have an unintentional death which results from a failure to maintain a certain standard of behaviour, or, as we might often refer to it, a breach of duty. So you can perhaps most easily identify this in a case, for example, of a doctor and a patient. There is a duty of care that the doctor owes to their patient, and there's a certain level or standard of care that should be maintained. And if there's an act which falls below that standard and causes death, it's possible that there's an offence of gross negligence manslaughter. You'll see that there are other forms of involuntary manslaughter too. Reckless manslaughter, and there's a question mark next to that because there's some debate about the existence and whether there should be this kind of involuntary manslaughter as a separate form. It does tend to focus on the defendant's awareness of risk of death or serious injury at the particular time in question, and whether or not that defendant has then gone ahead and done whatever it is they're doing anyway. There are quite a few concerns around this type of involuntary manslaughter which relate to fairness and issues such as fair labelling, but they're outside the scope of this session. The fourth kind of involuntary manslaughter that we see here is something called corporate manslaughter. And this is a situation where the question arises about a company's responsibility or potential liability for a death. Again, there's no intention to cause death or grievous bodily harm, but there is a question about corporate responsibility. There's been some reform in this area in more recent years, but it's actually very hard to secure a prosecution for this kind of involuntary manslaughter. The sorts of cases where this might arise have been where there's such things as ferry disasters or large-scale train crashes. And it's also something that was talked about in respect of the Grenfell Tower tragedy. Okay, so here's the question that we're going to consider in this. If you haven't already, download a copy of this to work on so that when I move through the slides you've still got it to hand. So this question then is about George. And George is invited to a fancy dress party and he decides to attend it wearing a scary mask from the film Scream and carrying a knife. He walks to the party in his costume, and on his way he walks past a post office. George enters the post office wielding his knife and says to the post office manager, "Give me some money or I will kill you." The post office manager, who has a weak heart, hands George some money and begs him to leave. George runs out of the shop, and the post office manager suffers a heart attack and dies. So we've been asked here to discuss George's criminal liability for the death of the post office manager, and that's what we're going to work through together now. The first thing that I'd like you to do is reread the scenario and see whether you can identify any of the offences we've talked about previously. Do try and give reasons for the answers you give. This is the all-important why that we often ask for. Now, I've suggested 5 minutes for this, but if you pause the video now, you can take as long as you need. What are your thoughts then? Did you think there was the actus reus and mens rea for murder here? No, there doesn't seem to be any evidence of George's intention to kill or cause GBH. So we're missing the mens rea element, if you remember back to that table. The lack of intention tells us then that this is probably a case involving involuntary manslaughter. What other facts and details did you think were relevant here? Did you see anything to do with somebody breaching a duty of care? Or was there any discussion of a company? No. So we're thinking a little bit about these different types of involuntary manslaughter. And what we do see is George engaging in criminal behaviour through his many actions. You might have highlighted his threat to the manager, for example, or taking the money, or wielding a knife. So we need to consider one of our forms of involuntary manslaughter, unlawful act manslaughter. Now, if you remember from the second table we looked at, the offence of unlawful act manslaughter has some elements which we must assess separately. These 4 elements were confirmed in the case of Larkin in 1944, and that's the first of our supporting legal authorities that we can use here. So what we're effectively saying is I need to establish these 4 elements beyond reasonable doubt to find George guilty of unlawful act manslaughter, and this was confirmed by the court in Larkin. So what you can see here is these 4 elements, the intentional act, an act which was unlawful, one which was objectively dangerous, and which causes death. So our 4 elements of unlawful act manslaughter. Okay, back to you for a few minutes then. I'd like you to take another look at the scenario and see whether you can find any details or facts which could be used to show each of these 4 elements. We're going to look at them in more detail together shortly, but for now, just see what you make of them. I've suggested a bit longer here, somewhere nearer to 10 minutes, but as before, just pause the video and take as long as you need. There's a lot to consider, but let's work through each of the 4 elements of unlawful act manslaughter and see what we make of George's actions. The first element, an intentional act, does mean that there has to be a deliberate act by the defendant, but there are some other important details too. The act must be voluntary, something that the defendant chooses to do, and it must be a positive act. This means it can't be a failure to act or an omission. This is a requirement of this kind of involuntary manslaughter, so it's something particular to this offence. Okay, so how does this apply to George? What did you spot from the facts? See if they match up with some of our thoughts here. Firstly, George's acts were voluntary. So he voluntarily entered the post office wearing his scary costume and the mask. He voluntarily wielded the knife and made threats. Those were voluntary actions. And secondly, we can say that by entering the post office, this is something that is a positive act. And we could cite Lowe, the case that's mentioned there, as our supporting authority. Good, so we're quite happy that there is evidence of the first element here, an intentional act by George. Secondly, we're told that the act must be unlawful. What does that word mean to you? So you might say an unlawful act is something that's against the law, or it's illegal. And you're right. It must be a criminal offence, and this was something established by the court in Franklin. This means that we're looking at the facts to try and establish whether George had committed a criminal offence here, and if so, which one? What did you think? The reason it's important to identify the offence is because we also have to prove the actus reus and mens rea elements of that separate offence. There's lots to do here, isn't there? So The offence in question is robbery, an offence under Section 8 of the Theft Act 1968. To help you out, because we haven't talked about that offence in this session, here's the application. I wonder if you spotted this, whether you spotted robbery. But the elements that we're looking at for a robbery offence is stealing money, so theft under Section 1, and all the elements that go with that. But in order to steal that money, either immediately before or as part of the same event, the use or the fear of the use of force. And we see this with George, with stealing the money, taking the money away, and also the threats and the wielding of the knife. So I think it's safe to say that unlawful act manslaughter is definitely a multi-layered offence. Not only do we have the murder-manslaughter distinction, not only do we have the many kinds of involuntary manslaughter, but we've also got to look at these separate unlawful acts, separate criminal offences. So I hope you got on okay with that. But this means that the second element is likely to be satisfied. So we have the first, an intentional act, and one which is unlawful too. Thirdly then, we have to ask whether or not the act was dangerous. This might seem a bit technical here, but what we're really thinking about is whether or not the act is likely to injure, cause physical harm to another person. And if it is, it's considered dangerous. This is a factual assessment and one which would be put to the jury to consider based on the evidence available. We talk about the act being objectively dangerous because we're asking whether the reasonable person would consider it to be so. So in George's case, the question would be asked of the jury whether or not the reasonable and sober person would recognise there to be some risk of harm to the manager based on George's actions. We also have to consider when making that objective assessment what information the reasonable person, and therefore the defendant, had or would have about the risk in question. So first of all, it would be the same knowledge as George, and we would make an assessment as to what George knew. George didn't know about the heart condition. There's some discussion about whether or not George should have known about that and been aware of that. Interestingly, it's been held that creating shock, as George did, can be sufficient for the purposes of unlawful act manslaughter. This last point here is recognising the change in nature of circumstances, and it's the case of an ongoing assessment as to what knowledge the defendant has, and therefore the knowledge that the reasonable person is likely to have. There's lots to think about there, but it's clear that George's actions would be considered dangerous due to the risk of some kind of harm in this instance. Fourthly then, is this final element of unlawful act manslaughter, cause of death. And what we're talking about here are the rules of causation, which we use to assess George's liability. This means we have to establish the link between George's actions and the outcome, the death of the manager. To do this, we apply some established rules. This means we first of all think about whether or not George caused the death both in fact and in law, and I'll explain a bit about what those mean. We also have to be satisfied that there's no intervening act or event that breaks that chain, and I'll explain what that means too. Factual causation asks, but for the actions of the defendant, the victim would not have died. Or to look at it another way, asks whether the victim would have died anyway. Legal causation is something of a legal safety net to ask whether the defendant's actions were more than a minimal cause of death, again, to look at it another way, whether they were a substantial and operating cause of death. So they were a significant part of the cause. And then finally, this third category, the novus actus interveniens, is asking whether or not there is anything that should remove George's liability by way of an intervening act. So something else that happens that affects whether or not George should be considered responsible. So to apply that then to the question, we can satisfy the but-for test. Without George acting as he did, the manager would not have died, based on the evidence that we have. The robbery, the unlawful act, is clearly a significant cause of death. It's a substantial event, and it's more than minimal in these circumstances. The question about the heart condition is really whether it would be fair and just for George to escape criminal liability because of the manager's health. The courts have said here that such a health condition should not have that effect. A defendant must take the victim as they find them. So the manager's heart condition is not enough to break the chain of causation. This means we can see a link between George's actions and the death of the post office manager. So to conclude, having worked through those four elements and the facts of the question, it seems likely that George would be convicted of unlawful act manslaughter. Brilliant. Well done. You've just worked through a criminal law taster session and practiced many of the skills that law students develop throughout their degree. There are also many of the skills that lawyers use once they are in practice. Just to recap, we've had a look at three main kinds of fatal offences and identified how and where they differ. In particular, the different actus reus and mens rea elements. We focused on the offence of unlawful act manslaughter, which is a type of involuntary manslaughter. Importantly, you use cases and legal principles to assess the criminal liability of a defendant based on a set of facts. And this has meant you've been analysing and evaluating the law and other information to reach conclusions. It's from here that we might then build a legal argument about whether or not George should be found guilty. I hope you've enjoyed the session and learnt a little bit more about the criminal law and legal skills too. Thank you.